Hi, I'm Christy Aslin. I handle wills, trusts, and probate. I wanted to go over some educational PowerPoint slides and also go over kind of my process so that you're prepared when we meet for the consultation. I'm going to share my screen. Just 1 second. I will pause this while I work this out. Okay, I'm back here. Let me try to share my screen. Okay, so this is about why you need a customized estate plan. And I think it can be really wrapped up by saying you want to prepare for death and incapacity. Sometimes when people look into creating an estate plan, they forget, or maybe they don't know that it's also here to protect you in the event that you become incapacitated. And then we also want to prepare and protect for death. We're protecting your assets, your loved ones, including your children and any other family members you might have, or close friends, whomever is going to be responsible for your administration of your assets after you die. So we will, with an estate plan, we're going to avoid probate. We're going to prevent loved ones from experiencing emotional financial distress. We're going to nominate guardians for your children if you have any, and also put a trusted loved one in charge if you become incapacitated. Okay, probate court is very expensive. It takes about 9 to 18 months to get through, depending on the complexity of the probate, the case, and the facts surrounding it. This is an estimate for what, I'm sorry, this is not an estimate. This is the amount of money that is the threshold for hitting a probate. So if you die and you have $166,250 in gross assets, okay, that is before any debts, it's before a mortgage or two, it's before any credit card debt. We're talking the gross value of your assets. If you have over 166,250, then you're looking at a probate, a petition that needs to get filed. Probate court, like I said, is very time consuming and expensive. And basically what the law says is if you have a landing place for your assets to go after you pass away, then a probate is not required. And the very best landing place for your assets after you die is for most people, a revocable trust. So my job really is to provide that landing place. These are the probate fees. I estimated it based on again, gross probate estate. So assets after you die, before any debts. If you have $1 million in assets, you're looking at $46,000. Now that's combined attorney fees and executor fees. The reason I chose 1 million is because it is very easy to hit $1 million if you have any real estate here in the state of California, with some exception. So there's a statutory set fee schedule, which you can look here on the screen. It's a little complicated, but I did the math for $1 million estate. You're looking at $46,000 in attorneys and executor fees combined, and this does not include any legal fees. So sorry, like court related legal fees. So like things like the cost of filing a petition, which is like $465, or the cost of having a probate referee value your assets. Those are not included. So you really want to protect your family from unnecessary emotional distress. Let's say someone has a massive stroke one day, they're a homeowner. Let's say they go into a coma soon after, in that event, if they're a homeowner, the family is going to have to scramble to figure out what to do to avoid the pangs of going through probate. In addition to the fact that they are really going to be grieving that person and potentially the loss of that person as well. So putting together an estate plan is not just for you, but also for your loved ones as well. We also want to set up guardians for your children. I have a child. This is typically the biggest issue for people when I talk to them. Well, if they have young children, this is like the biggest issue for them. So before we meet, I want you to think about who you would trust enough to nominate as potential guardians for your children. And the reason it's important to do it this way is because if you don't nominate guardians, the court is going to, okay? You also can nominate trusted loved ones to step in for you in the event of incapacity. For instance, if you become very, very ill, or fall into a coma, you can have people act in your place, trusted loved ones, probably a spouse if you have one, potentially a brother or sister, or mother or father, or boyfriend or girlfriend, or partner, whomever. You want to have them come in and make decisions for you. And those are with regard to healthcare decisions and also financial decisions. So how does this all happen? Well, I consider it kind of a choreography of 3 separate elements. First, we have the documents, which I've been referencing, which include the will, trust, powers of attorney for financial decisions, a healthcare directive, and then funding. I'm sorry, that's my 3rd element. Forget I said that. A deed, though. You want to have a document that transfers your home from your name as Christy Asselin to Christy Asselin, trustee of the Christy Asselin Trust. I just made that up. We'll also look at your beneficiary designations. People are sometimes, these are just, they become out of date. So we want to make sure that you do a little bit of homework. We check in on who you've designated as your beneficiaries for your any retirement accounts. We also want to see if there are any designated beneficiaries on your any checking or savings accounts. Those may be consistent with your wishes, they may not be. And we also want to look at funding your trust. This is so critical, and people, even though every time I meet with a potential client, I go over these exact same words, sometimes people just forget to do this, and it's so important. When you create a trust, it is an empty suitcase. You have to put things, you have to put your assets into that suitcase in order to avoid probate. I have a friend. She served as the executor on her sister's estate. Her sister had created like a Zoom, not a Zoom, what is it called? Legal Zoom, like a legal Zoom estate plan. She felt very confident walking away from this legal Zoom estate plan and felt that she had done everything that needed to be done. But if you look at those legal Zoom estate plans, by the way, it'll say this does not qualify as legal advice. It is not customized. They aren't giving you legal advice. That's why you need to have a customized plan. So she walked away from this plan feeling very, very confident that should she pass away, everything was taken care of. Well, it wasn't, because she forgot to fund the trust. She listed her home as an asset in her trust, which I always will do, and then did not change title. She did not change the wording on her deed to say that she owned the house now as trustee. So cut forward several years, now she passes away, and my friend served as her executor because she had to put the home into probate, and it cost my friend a lot of time, a lot of stress. And I think it was a pretty expensive home, because she said it was something like $66,000 to get through probate. And I didn't ask if that included her fees or not, I'm not sure, but we want to make sure all of these elements, documents, beneficiary designations, and funding, we want to make sure all of those things are taken care of, okay? The documents, very quickly, the will is really your way of gathering and assigning all of your assets to the trust. The trust says, listen to my instructions, and has a very long list of instructions setting forth your wishes as to what happens to your assets after you pass away, or if you become incapacitated, who's in charge if you die, etc. Your financial power of attorney says, take care of my finances when I cannot speak for myself. Medical power of attorney, advanced healthcare directive, says, speak for me if I cannot speak for myself as to medical decisions. So my process really is 5 steps. The first is, if you decide to hire me, we will meet and have a discovery call for about an hour. And then I get to work and I draft the documents. Meeting number 2, we meet again, we go over the documents. As a little caveat, these documents are complicated. They are unfortunately not for any attorney, frankly, probably for LegalZoom as well. They are written for you, but they are also written for subsequent attorneys to interpret and the court to interpret. So the language in here is complicated. So I'd like to schedule meeting number 2 to answer any questions. This is really led by you to ask me questions, anything has popped up during your review. Third meeting, you sign the documents with a notary. I work with a wonderful local notary here in Los Angeles. And he gives me a great deal on the cost. So I just pass that along to you, and you're responsible for the notary. Fourth is I get everything back and I process everything. That means I scan everything. I will, record the deed for you, transferring your house into the trust. I take care of all of that. Then I hand everything back to you. I do not, unless you request, print out documents. Not everybody wants it. Some people are very happy with a flash drive. But if you want to add another flat fee, I can print out a binder for you and arrange for you. The fifth part is so important. The fifth part is the funding meeting. 90% of my clients don't do this, even though I tell them time and time again, it's really critical. So please file this in the back of your head. No matter who you hire, you want to make sure everything is funded properly. You want that suitcase full for sure with all of your assets. All the assets that can be placed into the trust, that is. So we would meet, we'd go over any questions you have. I can even email back and forth if that's more convenient for you, but this is a really critical issue. So I look forward to meeting you. And if you've got questions about pricing, it's actually all on my website. It's very transparent. Go to lawyercma.com and click on the estate planning tab, and it is all out there. Okay, look forward to meeting you.